that, refuses to do anything that my client ever tries to do.
But
And
that's
so
not true.
it's completely true.
Okay, moving on then, we've got two motions on M Kellman, 105037. And Ms. Dwiggins, I think, just stepped out for a moment,
Yeah.
so. And then I think we've got, yeah, we do, we have Mr. Park. Okay, we're ready then to get the appearances of the parties. We'll start with the petitioner.
Good morning, Your Honor. Douglas Gerrard, Cox Larson, on behalf of the petitioner, Michael Kellman.
Present in the courtroom and for respondents.
Good morning, Your Honor. Dana Dwiggins appearing on behalf of both Joy and Sherry Kellman, who are present on the phone on Blue Jeans as well, I believe.
And then appearing remotely.
Good morning, Your Honor. Matt Park, board number 12062, on behalf of Mitchell Kellman and Lindsay Kellman Grunberg, beneficiaries.
All right, thanks very much. We have two issues that are on today. The first of these is, and so I'm trying to figure out the order to take them in. We have the issue on payment of rent to compel sale of trust property, and then we have a motion to enforce a settlement agreement. So I'll hear the suggestion of the parties how to do these.
I think maybe taking the settlement agreement first is probably best.
Ms. Dwiggins.
I'm fine with that, but Mr. Gerrard and I discussed reaching some type of agreement that I thought we were going to present on the record.
Okay. And Mr. Park, those counsel who are present may have something they want to put on the record, but otherwise, settlement agreement first.
Yeah, that's fine, Judge.
Okay, all right, so counsel wish to be heard first, and then we'll discuss if that impacts how we're going to proceed.
Thank you, Your Honor. So the purpose of the motion was that this settlement that was reached more than a year and a half ago, we've not been able to ever get a final documented agreement in place, signed off on by all parties. And the final sticking points were two. One was that my client's understanding was always that he was being reimbursed for money that he had advanced in his petition on behalf of the trust to try to recover trust property. And that was the final sticking point for my client being able to sign off on the settlement agreement, and Ms. Dwiggins' clients signing off on it as well, because they were not comfortable with the language that was in kind of an amendment to the agreement that we'd all negotiated to make sure that that was made clear. This morning out in the hallway before we started, Ms. Dwiggins and I talked about a change to the language of that amendment that would still reflect that the money was being advanced on behalf of the trust, and that the money would then be paid, instead of directly to my client, would be paid to the trust, and then the trust could pay it to my client. And in that fashion, we can make it clear to the IRS later on that this is a reimbursement of funds that were advanced on behalf of the trust, rather than a payment being made by Mr. Wiggins' clients directly to my client that for whatever reason might be unrelated to the trust. In other words, we wanted to make that pathway clear so that he's not taxed on that money. And Ms. Dwiggins agreed to a change in that language. I can put that on the record, but there was a sentence in the amendment that we put together to try to get this accomplished that said, oh wow, it's a very long sentence, but it says that the $125,000 would be paid, quote, as reimbursement from the trust of Michael of the attorney's fees he advanced on behalf of the trust to seek a recovery of trust property through the initial petition. And we've agreed to just change that to say, as reimbursement from the trust of Michael of the attorney's fees he advanced on behalf of the trust, period.
Mr. Park, had you considered this? Did your client take a position on it?
No, Judge, we don't take a position, but we're fine with that. That doesn't affect my clients.
Your Honor, just to bring up his clients, Mr. Gerrard and I had negotiated this settlement terms quite a bit amongst ourselves over the course of months. There were delays on both our sides, but come December, when it was ready to be finalized, Mr. Park had been copied on everything, and when it came time to sign it after making some clarifications and revisions, he indicated his clients will not sign it. And I know Mr. Gerrard wants it signed, I would like it signed. They technically made an appearance before the court. They agreed with the settlement on the record, and we just request that this court have them sign it as well.
So now that goes right into the next issue, which is the petition to enforce the settlement agreement.
Right, that was,
Yeah.
that's this petition, that's what we're talking about.
So now
Your Honor, just,
yes, Mr. Park.
I'm sorry, just to address that, Judge, if I can really quickly. If my clients don't wish to sign the settlement agreement, all they agreed to was having a certain amount taken off the top, which would affect their interest, which that part we do agree to. The rest of it, Judge, was between Ms. Dwiggins' client and Mr. Gerrard's client. So my clients don't want to be bound or essentially to sign anything that they didn't, you really bargained for. But they're okay with the part that affects them, which is the small amount of money, I think it was $20,000 taken off the top.
Okay, so I guess here's my question. Do you need them to sign? What is it that you need them to sign? If they essentially agree to this change, this isn't their issue. They've agreed to this amount of money. So what is it about the settlement agreement that you need them to sign? And then we can hear from Mr. Park about, why they don't want to sign it.
Well, that was the second issue we put in our motion, right, our petition with respect to compelling the performance on the settlement. I think Mr. Park is correct that by and large, the only thing that directly affects his clients is that $20,000 is going to be paid from the trust as reimbursement. Well, originally it was going to be 20, now it's going to be a total of 125 plus the additional 20, but only the $20,000 was going to come off the top that would affect the distributions to Mr. Park's clients. And we understand that that's a part of the settlement. He agreed to it on the record, as did his clients, at the hearing in which this was all placed on the court's record. So at least with respect to that part, they need to sign the agreement, if only for that. But we also are concerned because there are releases that are being given in the settlement agreement between and among all of the parties to the settlement agreement. I don't know what the concern is on Mr. Park's side. I haven't heard what that might be, other than that they just didn't want to sign it. I have heard that. But I don't know why, given the fact that the settlement that was originally placed on the record said that there were going to be releases between all the parties on all of these issues that were being resolved, what the concern would be. But we wanted to make sure that my client is a trustee of the trust. I'm sure Ms. Dwiggins, for her client, is a trustee of the trust. Wanted to be sure that there aren't, there's no buyer's remorse later on. There's no issues that are going to arise as it relates to the issues in the settlement later on, that everyone is releasing everyone to the extent that we had originally agreed to. I think that's the reason why we wanted their signatures on the agreement, so that it's clear that they agreed on the record in front of your honor. That part I agree with, but I don't want them coming back later and saying, well, we don't like the way that you, Mr. Kellman, as trustee of the trust, did this, that, or the other related to this issue. And so, we want to make sure that those releases are in place. And that was what was contemplated originally. So I think that's the reason, from my client's perspective, why we would like to have that, so that it's clear that the record is consistent with what we said in front of the court, and that the settlement agreement that's signed is consistent with what was placed on the record of the court.
Okay. So, Mr. Park, looking back here at the transcript, the original hearing, what you said at the time was they did authorize me, and we don't have any objection. The only issue affecting them is the $20,000 off the top of the trust, and they're fine with that. We'll go ahead and work with Mr. Gerrard and Ms. Dwiggins on a written settlement agreement. So Mr. Park was authorized to speak on behalf of his clients, understanding the terms, and authorized him to proceed to work on the terms of settlement agreement on their behalf. All right, so I guess that's sort of my concern, is is it possible to do a carve out or are there portions
I
of
think
this?
so, Judge.
Pardon?
I think so. I think they can sign us to the $20,000 that they absolutely agreed to. I think they can sign us to that. I think their concern is that, this really was a claim between, now co-trustees, right? But before, it was, Michael was the one who had all the affirmative claims, and to the extent there were counterclaims by Ms. Dwiggins' clients. Those were the claims that were really litigated and compromised and eventually settled in this case. While my clients, did appear and they did, observe hearings, their concern is that they're going to be put into a settlement agreement that they didn't negotiate because they didn't have claims in this case. They didn't file claims in this case as beneficiaries. They observed, Judge. And so I think I can absolutely show up and the only authority I have is to agree to the $20,000 off the top, which is what we've agreed to on the record and which we could agree to with respect to signing it, Judge.
So what I'm understanding, the two remaining trustees, their concern is that they were resolving all the litigation and they want all the litigation to be resolved.
Yes.
Yet your clients didn't raise any issues in this litigation, but
So why would they be required to sign off on it?
that's my question. But with respect to the opportunity to raise, they were on notice. They appeared. They did not raise any issues. So maybe there's a way to write it that says that having received notice and having raised no claims, they take no position on whatever the resolution is. They had their right to raise their objections and they didn't. So I think that's really the question: is are they bound by this, such that the release between the other parties and what they have resolved with respect to all the other litigation? I understand that the $20,000 is the one specific issue that affects them because it affects their distributions, but they have raised no other objections, and maybe a separate part of the settlement agreement. They specifically consented to the $20,000. They raised no objections, although on notice of this litigation
And interested parties.
and having participated, they raised no objections and have taken no position on any of the other issues. So perhaps, Mr. Parker, is a way to write this settlement agreement that specifically says these are the only things they're agreeing to. They were on notice of everything else and took no action, raised no objections,
Judge.
taken no position.
Yeah, and Judge, I understand the court's concern. I understand Mr. Gerrard and Ms. Dwiggins' concern. Maybe I could draft some language and propose it to both sides, and run it by my clients, obviously, to get authorization for it, but then, propose it to both sides and see if it's something that would make sense.
Well, here's my concern is that
And I could do that expeditiously.
I want this done, as I think the parties do. And we did have a settlement, and that was their opportunity. If they wished to raise any issues, they are on notice, they participated. They've taken no position on any of these other issues that were resolved by the other parties who did participate and litigate those issues. They took no position on any of that. The only thing that impacted them was this $20,000. They've consented to that. So having been on full notice of everything throughout this litigation, they have not objected in any way and understand the settlement that's been reached by the other parties.
That's fine. If Mr. Park wants to send over language that's consistent with what the court just said, we can, Dana and I can try to incorporate that into the agreement if that's where this is going. I mean, it's always been kind of a side issue to what it is that we're trying to get resolved.
Right.
For certain, but they are an interested party. They were noticed of what happened, and they had their opportunity to participate, and they did. I mean, to say that they didn't participate is not correct. They appeared at all the depositions, they appeared at all the court hearings, so they did appear, and they were a party to the settlement. I understand what Mr. Park is saying. If that's the way that the court wants to resolve it, then we'll try to resolve it in that fashion.
Right. And that's the most important thing, I think, is to make it perfectly clear that they were on notice of all these issues. They participated fully in this litigation. They have raised no objections to this resolution of the matter proposed by the parties. So the important thing is they're on notice. They participated. And they don't think this is their issue. That's fine, but they're on notice of it. and it's been resolved,
Understood, Judge.
and they are,
Understood, Your Honor.
I think my client's concern was affirmatively making releases and representations when it wasn't their claims. That was the concern. So
okay.
I'm happy to draft up some language and pass it by the council.
So with respect to the motion to enforce the settlement agreement, I would grant it to the extent that language be proposed that would clarify that the litigation between, that these parties have participated throughout this litigation, they were on notice of the issues, that their concern is the specific portion that addresses this $20,000, that they understand the other parties have resolved all of the other issues, and that they're on notice of the resolution of all the remaining issues. That's the important thing.
Your Honor, one
They
other
have
point
notice.
as it relates to Mr. Gerrard's petition and our opposition to it is our request for attorney's fees. My clients have signed this agreement twice now, once on December 30th. Once language was agreed to Mr. Gerrard and he agreed it was finalized, and then he thereafter informed me that there were errors. I sought to follow up to finalize those. I spoke to him on February 3rd. We changed the language, agreed it was finalized. My client signed that day. It was thereafter that his client refused to sign and wanted this amendment, which changed the term of the trust. And I have tried multiple times to tender the settlement amounts by asking for his client trust account information so we could wire it, but he has refused to give it to me. And in fact, I tried to give him a check today that he won't even take because he wants me to deposit it into the trust versus him depositing it into the trust. So to me, this all could have been avoided and should have been avoided because my clients have signed the agreement and did so back in February based upon what was agreed to be finalized at that time, and this issue came afterwards.
And so your clients want
Our attorney's fees incurred in connection with this motion,
paid by,
paid by Michael.
And we filed the same thing, asking for our attorney's fees to be paid because this settlement agreement was reached nearly a year and a half ago. It was March of 2022 when the settlement agreement was reached. And the only reason why it was never resolved is because Ms. Dwiggins' clients refused to acknowledge that the money that was being paid to my client was to be reimbursed as an expense that had been advanced on behalf of the trust. And he wasn't going to be taxed on that payment that gets made when he was advancing on behalf of the trust to get property back in the trust that was improperly removed by Ms. Dwiggins' clients. That's what happened. That's what this petition was about. And we raised that. And Ms. Dwiggins said, I don't want to put it in the settlement agreement that we've drafted. I want you to put it into a separate amendment. And put that in a separate amendment and send it to me. I'll get my clients to sign it. I put it into a separate amendment. I sent it to her. And then her clients refused to sign it. And the first time that I was ever told that they would be willing to resolve that issue by making the small modification to the language was this morning before we entered the courtroom. And Ms. Dwiggins did, in the last couple of weeks, several times try to ask us for our trust account information so she could wire transfer the $125,000 to our trust account. And I said, no, that defeats the purpose of what it was that was the concern. That the money needs to be routed through the trust so that later on, if he's, my client gets challenged by the IRS as to his tax treatment for this $125,000 payment, which was money he advanced to get this property back in the trust, that record is clear, that paper trail is there. And the original settlement that we reached was to reimburse him for money that he advanced on behalf of the trust. We wanted to make that clear. So, we asked for attorney's fees in the motion that we filed because we don't think this should have taken a year and a half to do. Ms. Dwiggins now asking for attorney's fees on her side as well. I posit to the court that all we've asked for is that what we'd originally asked for be carried out, which is that my client be reimbursed for the money that he advanced once Your Honor ordered that the property come back into the trust. And that was the settlement that was reached, was that he was going to get paid his attorney's fees back, $20,000 out of the trust directly, and $125,000 was supposed to come from Ms. Dwiggins' clients.
Your Honor, just very briefly, that's not entirely accurate because this issue wasn't raised until after February 3rd, after the agreement was finalized, and after my client has signed it for the second time. Indeed, his client initially signed it on December 14th, I believe, or 13th, and it did not contain the language that he wanted. And the only reason why my clients wouldn't sign that one was because the releases weren't parallel. And Mr. Gerrard and I ultimately worked that out, which resulted in my client signing it on December 30th. And then when he raised that there was an error in the settlement agreement, we got on the phone, fixed it, finalized it, my client signed it again. It was only after I tried to follow up with him on where his client's signatures were at, where his client's signature was at on the agreement, that he raised this issue for the first time. So there hasn't been any delay or refusal on part of my client. Mr. Gerrard easily could have taken it in his trust account. It doesn't need to flow through the trust. It doesn't, we do that all the time as attorneys in settlement agreements. And he could have easily taken the funds, and if that was a concern of a paper trail, he could have deposited it in the trust himself, and his client could have turned around and cut a check. I mean, he won't even take the check from me today.
Unfortunately, my client does not have the ability to act on his own. You know, there are two trustees of this trust, and the other trustee of this trust will, refuses to do anything that my client ever tries to do. And
That's
so,
not true.
it's completely true. So the point here, Your Honor, is that it's been a year and a half. You notice that nothing was going to get finalized until we filed this motion to compel.
That's not true.
So
Okay, Counsel, please.
we very clearly provided the amendment that Ms. Dwiggins asked for to resolve this issue, and then her clients refused to sign it. That's where it ended.
Right.
And that amendment only puts into place exactly what the parties originally intended, was for my client to be reimbursed for the money he advanced on behalf of the trust. His tax accountant told him that he needed to make sure that that money flowed through the trust, and Ms. Dwiggins' clients have refused to do that. It's that simple. So
here's, generally, one expects when parties resolve a case that, and the language is typically parties to bear their own fees and costs. That's the idea. You work this out with your clients, how you're going to get paid with your clients, and that's just expected, that you are going to incur some additional cost in getting something resolved. This is not your typical. I appreciate the fact that this is not the typical resolution where then we immediately went in, had our paperwork done, and we're done. It's easily resolved. But this is a dispute between the parties as to who was more responsible for the delays versus less responsible for the delays, and why should, and since there's even this dispute with Mr. Park's clients about why they wouldn't sign, it's been a struggle to get these parties to agree to language to resolve a case. The resolution was reached, and it's just a question of the language to resolve the case and the logistics. I appreciate Ms. Dwiggins' point about why does it have to be from the trust versus paid into an attorney trust account and run that way so that it's clear, it's not income, it's a reimbursement. You call it a reimbursement, it's a reimbursement. So just because a tax accountant is being fussy, it seems to be, a concern that one of the parties has. They're following the advice of their professional advisor. It's unusual that it's taken this long. We typically don't expect to take over a year to do a settlement agreement. But March 8, 2022, orally on the record. And so that was our hope, was that we had it resolved and the parties were going to be able to move forward and get this finally distributed and be over with. It's a question of who was more responsible for these delays, and there were delays on all sides here. And so who's going to bear the cost of that? Typically, you bear the cost of whatever resolution yourself, because the case has been resolved. You're going to deal with whatever it takes to get it done. The burden's on you, because that's typically the language, is that the parties bear their own fees and costs. That typically has to do with post-resolution, just getting the thing wrapped up. It's part of the job of the parties and their counsel. So at this point, I don't see a basis to assess attorney's fees against either party or any party, even Mr. Park's clients. Everybody had their reasons for why this particular settlement agreement took so long to get worked out. And I do think that at this point in time, it was necessary for Mr. Gerrard to file this. We finally have got this worked out. The parties worked out some of it on their own. Courts ordered Mr. Park to come up with some language that will put his clients on record as having had notice and having participated and having elected not to sign the settlement agreement. But nevertheless, they're on notice of all the terms of what's been resolved. So they can't argue they don't have notice. That was the bigger issue for me, this whole question of who fought over this language versus that language to delay getting it signed. Again, I think that's just on the parties. They all have their own actions. Why they've taken them are their own. They're all acting on their own advice of their own respective consultants. So I don't see a basis to assess attorney's fees against either party because it's really kind of a sanction, and I don't see that it's a sanction. So if this is something where at this point the acting as trustees, it's appropriate for some portion of this to be paid by the trust because it's the trustees acting on behalf of the trust. That's different. So to the extent there's some portion of these fees that need to be paid by the trust, that I would consider. So as I said, I would consider if some portion of this is attributable to the trust, then that's a different issue than assessing against one another as any kind of a sanction. Mr. Park.
Your Honor, I just want to, as a housekeeping, I just want to make clear on the record that I haven't seen the language that Ms. Dwiggins and Mr. Gerrard agreed with respect to the treatment of the $125,000. And so I can't take a position on that, and obviously until I just want to make sure that I hadn't assented to that on the record or anything. I just want to take a look at it first.
And I'm happy to send that. It's the same amendment that I sent you before, and I just read the only change on the record that would be made.
Right.
But,
And so the only thing is to add this language with respect to Mr. Park's clients. I would otherwise order them to sign something acknowledging their participation throughout the litigation, their participation in the settlement conference, and then their notice and knowledge. That's what I'm asking them to.
Understood, Judge.
With respect to the request for attorney's fees mutually against one another, I don't see a basis for that. If there is some basis to assess attorney's fees to the trust because of actions taken for the trust, and that's where I was saying, filing this particular motion, it seems more like with something on behalf of the trust, then I think those are properly assessed to the trust. But as a sanction against one another, no. We have the last issue, and I think that Ms. Dwiggins wants to know if Mr. Gerrard's going to be ordered to take the check.
My concern is, I mean, neither one of our clients could act on their own, and this is requiring them to act again. It contemplated it was going to go to his trust account. I've had the funds in my trust account. I mean, it clearly states it says as reimbursement. So I disagree
So do we need
with
an order that is, the court has ordered Ms. Dwiggins to pay to Mr. Gerrard trust account on behalf of his client the reimbursement the court has previously ordered.
That's
So
fine.
there's a paper trail.
I just
that
want to
perhaps
avoid
would
the
satisfy
client's
you.
involvement and tender the payment as my clients agreed to.
and we would obviously prefer that it be routed through the trust bank account. The trust has a bank account. That money can be sent to that bank account. We already have a court order that authorizes the distribution from that bank account to my client for the $20,000 and can be for the $125,000
Okay.
as well. And then, so maybe just authorize my client to unilaterally write a check from that bank account to himself for the $145,000.
Ms. Dwiggins, this is a trust account from Ms. Dwiggins' trust account made payable to.
It's made payable
Gerrard's trust account.
to me right now, and I would rather have it be payable to the trust and go, directly into the trust, and then we can take the money out of the trust.
We have a settlement payment right here, and that is jumping through so many different hoops.
So if you want a paper trail, you can certainly do a paper trail, but the court has ordered Ms. Dwiggins from funds she holds in her trust account to make a distribution to counsel in trust for his client, reimbursement for as previously ordered by the court. I'm ordering you to take it, and we're done.
Let the record reflect I've tendered it.
And the record reflects that that check has been tendered, so I appreciate your client's concerns and that he's acting on advice of his counsel, but,
And we'll,
that's counsel, advice of his accountant. But the court is ordering that Ms. Dwiggins get this done post haste, so that's been accomplished.
and ordering that it is a reimbursement from the trust of money to my client.
Yes, so we need an order,
Yeah.
and are you gonna do that, Mr.
I
Strike?
can do that.
Okay, all right. So that is included in the order, and Mr. Park is going to send you language acknowledging his client's full participation throughout notice of participation throughout this litigation, and subsequent settlement. So Mr. Park, I'll send you whatever that language is. Now, with respect to this other question, which was the issue on rents.
Okay, so that's a separate motion.
And that's partly resolved as well.
So, well, maybe, it depends also on Mr. Park, right? So what, this issue deals with the house. Your Honor may recall that there was a property that was owned by the trust. It was transferred out to, joint tenants, Ms. Dwiggins' two clients and Mildred-Kellman, and then was ordered by the court to be let back into the trust, and it was deeded back into the trust in March of last year, 2022. So for the last year and a half, that property has been in the trust, but Ms. Dwiggins' client, Joy, she moved into that property at least back in 2019 when the caretaker that was there at the time, who testified in her deposition, made it clear that Joy was living in the house. We have no reason to believe that she's ever moved out. After Mildred died, certainly all the utilities have been being paid, including, for instance, internet. There's no reason to have that house other than that Joy is using it, and she's been paying out of the trust all the expenses associated with the house, which is proper as it relates to maintaining the landscaping and just paying for other utilities, but it's improper to the extent that those utilities are being used by Joy Kellman if there is no reimbursement to the trust for her using the property. So what we asked was for two things. One, we asked that this property, my client, be given authority to sell the property because it hasn't been sold, and the trust at Article 4, Article 3, required that upon Mildred's death, the trustee would forthwith distribute the trust estate, and my client, under our statute, does not have the ability under NRS 163.110 to act unilaterally because there are two trustees, so it requires both of to do anything. In the meantime, around December of last year, and it started before that, it started at least a couple of months before that, Joy, one of the trustees, and Sherry, one of the beneficiaries, through Ms. Dwiggins, indicated that they wanted to buy the property. And the discussion that was going on at that time was, could they take their share of the distributions out of this trust and apply it towards the purchase price of that house, and potentially get some money from another trust that's not before your honor, that would allow them to pay the full purchase price of the property. And that was the original discussion, and it involved Mr. Park's clients and it involved my client as to what amount they'd be willing to sell the house to Joy and Sherry for, as opposed to a third party so they could just make a normal distribution. And in December of last year, Mr. Park's clients and my client both agreed on a price. Yes, they would be willing to do this for a specific price, which had been being discussed back and forth. And my client's understanding was that there would then be a purchase agreement so that there would be a discussion about what the warranties would be, what covenants were going to be provided. In other words, we wanted this to be an as-is, where-is sale with no covenants or warranties, so that they can't come back later against the trust and say, well, we found a water pipe under the house that was broken and we want to make a claim against the trust for some other money. So the idea behind this was that it would be over once and for all. My client expected that the purchasers, Joy and Sherry, were going to put together a purchase agreement. They talked about having Dana Dwiggins prepare that, was in emails. My client said he'd be willing to have his attorney prepare it, but there had to be an agreement that the trust would pay for that preparation. Nothing happened. Mr. Dwiggins' clients never prepared and forwarded any sort of a purchase agreement that would cover all those things, and that brought us to finally filing this motion a year and a half after Mildred, more than a year and a half after Mildred had passed away, saying, let's get this done. My client needs to be given authority to sell this. Joy wasn't willing to do anything to sell it to a third party because she wanted to buy it herself. So that's why we had to eventually file this motion, because we needed this to get on track. We needed this property to be sold, and we wanted Joy to reimburse the trust for her use of the property. In response to our motion, we received a brief opposition that essentially said, Joy's not living there. And so she shouldn't have to pay for these, any expenses back to the trust. She shouldn't have to reimburse for utilities or things that she's using, and she shouldn't have to pay any rent for using this property. We don't have any way to prove or disprove without some sort of a extended evidentiary hearing, which we don't think is worth the time and money to go through, to determine whether she actually did move out. Shortly before this hearing and long after the reply had been filed in response to the opposition, we received a supplemental opposition that had a whole bunch of declarations, which was clearly outside, a violation of the rules. It's outside the time period within which they had to file their opposition. And these supplements just had a bunch of affidavits from neighbors and people who said, well, we would see Joy get picked up from this property, but that doesn't mean that she's not there, and it doesn't mean that she's not using it. And in fact, in their opposition, they admitted at paragraph 9, I think, of their opposition, that Joy was spending
several hours a day there.
Yeah,
So it looks
4 to
like
6 hours a day, but it doesn't take 4 to 6 hours a day to maintain a property. It takes maybe visit it once a week for 20 minutes, make sure that everything looks good and everything's being done. You don't have to stay there and live there and work from there, and you have your internet there and have your bank account statements forwarded there. I mean, this is not a normal use of trust property. My client's not using the property. He's the other trustee. The other beneficiaries, they're not going there every day and spending 4 hours a day and, at the property. It's using trust property. That's not going by to make sure it's being properly maintained. So,
okay, to a certain extent, I agree with you. But on the other hand, any property that appears, and I don't know if this is like in a gated community or someplace where it would be
it is in a gated
little
community.
bit more protected, but any property that is not being regularly occupied is at risk in Las Vegas. We all have heard of horror stories.
Sure.
So I'm not saying it's inappropriate to do something that sort of makes sure that the property appears regularly used, that somebody's regularly there, so anybody who's observing, you said the neighbors who happen to notice, that somebody's coming and going on a regular basis, so the property's not entirely abandoned. But if there is something that's being used specifically and solely for one person's benefit, I understand your concern that that's perhaps not a proper trust use, but like internet, why would you need that? But otherwise, I just, I see the need to give the appearance that someone is there and someone is using the property on a regular basis, such that bad actors don't see it as an easy mark. Mrs. Dwiggins, with respect to, was your client just like, absolutely not, we aren't using it, we shouldn't pay anything, or are there certain expenses that were unique to your client?
I don't think any expenses need to be reimbursed. As we explained in the opposition, she goes there 4 to 6 hours a day to make sure the property's taken care of, it doesn't look abandoned, and someone's regularly there. She's not only the trustee of this trust, but other family trusts that aren't before this court, in which she conducts trust business on, which is why she uses the internet. She has the trust bank account statements, not her own personal mail, going there. And so she makes sure when she's there protecting the property that she's just doing trust business. And so that's why the internet's on. but she's not residing there. In fact, she moved out and moved into her twin sister Sherry's house after Mildred passed away because of the ongoing disputes with Michael, and she didn't want to continue living there and have these very issues. So we think it's proper what she's been doing. In
So
relation,
essentially, she's using it as a family office.
essentially, and making sure that the property looks occupied so it isn't subject to vandalism or squatters or anything of that nature. But in relation to the purchase price, again, his client seems to put the blame on my client for everything, not realizing he's a co-trustee and he has an obligation to do things as well. In an email that we attached to our opposition, he specifically said in an email to my client in December of last year that Richard, who is Richard Chaplin at Mr. Gerrard's office, is the trust attorney, and I feel strongly that he drafts the transaction paperwork given that counsel the seller leaks the documentation during the real estate purchase. My client responded and said that Richard only represents you, Dana's my attorney, but either one of them could do it. The money, half of the sale price, since my clients would be entitled to half the sales price since they're each 25% beneficiaries, $750,000 is the agreed price. I currently have and have had for months, a couple months at least, $375,000 in my client trust account that we're willing to tender $187,500 to Michael Kellman and $187,500 to Mr. Parks to be split between his two clients, Mitchell and Lindsay. And I could do that as early as tomorrow. We talked about the distribution agreement that I proposed. Mr. Gerrard told me he's fine with it. The only thing he wants to put in there is that the property is being distributed in kind as is with no warranties. I said that was acceptable, so to me, that issue is resolved as well.
Okay. Mr. Park, again, did you want to take a position?
Thank you, Judge. No, listen, as they mentioned, as Mr. Gerrard mentioned, I think the purchase price, I think they did consult with my clients early on. Other than that, we don't have a position. I think what Mr. Gerrard has discussed makes sense, but my client doesn't take a specific position on that.
So if she were actually living in the property, I would agree. I think Ms. Dwiggins has made a valid argument for why certain utilities are needed. Like I said, I didn't understand the internet, why anybody would need internet, got your cell phone. But this is an interesting issue, that there are other trusts, and that essentially this is, while she's over there, making it look like somebody's in the house, she can conduct business for all the various trusts that she's responsible for the other business of the family. That's an interesting argument. So Mr.
It's an interesting argument, but there's no evidence of that. There's no evidence that that's what she's doing. There's no evidence that it takes her 6 hours a day to do trust work. There's no evidence that it takes more than an hour a week to go by the property and make sure that it's okay, or even an hour a day. But 6 hours a day, every day, using the trust property, and all the while, we can't get the property sold, we can't get it moved forward. That's the issue. That's why we're here. That's why we had to file this petition. It's not my client's responsibility to draft a purchase agreement for these purchasers of the property. That's their obligation. If they're the purchasers, they need to do it. My client said he would do it. The email that she read is exactly right. He said, I will have an attorney do it for the trust. They responded, Ms. Dwiggins can do it, or they can do it, but they never agreed that the trust would pay for that. And my client doesn't agree that the trust should pay for that because it's their purchase. If we were selling this on the open market, some third party would come in and they would send us a purchase agreement. And so, that's where we're at. If we agree with the price, we agree to go forward with the sale, with the in-kind distribution and receive the money. We agreed out in the hall this morning that we would be willing to do that as long as Mr. Park's clients are okay with it, because we haven't heard from them, and it would require their consent as well. So if they're willing to go along with that purchase price, and they're willing to say on the record that that is acceptable to them, then my client's fine going forward with that. That doesn't resolve the issue that Your Honor started to talk about. about why it takes a year and a half and why she needs to spend 6 hours a day at the property for a year and a half. I mean, that's not managing the property. That's not taking care of the property. That's just spending her time there that she could spend somewhere else. And I think that's frankly been one of the reasons why there's been a delay. is 'cause
She could
she's-
go to Starbucks, but what difference would it, what business would it be of your client? This is what I'm saying, is why does your client care? If she does this at the library, or at the local Starbucks, or at this house that the trust owns?
It only matters
Why
if
does
it's
your
delayed.
client matter?
It only matters if it's causing a delay in getting this property sold and moved forward. And that's what we think has been
I
going
don't
on.
see any reason why she's hanging onto this property so she can go there for 6 hours a day. Sounds to me like all of these disputes have been, no offense, people just need to move on. By which I mean your respective clients. You have resolved this matter months ago. Council had been very diligent in getting all of these issues resolved, but doing everything you need to do for your clients has resulted in these disputes over these less significant issues that now are just festering because it's the last thing that's left. Now we have this house left. We've got all these other things resolved, so now let's fight over whether or not you've been spending time there by asking neighbors if you see them coming and going. These people just need to get on with their lives, and this isn't helping. They have this case resolved. They need to just move on, and I appreciate the fact that everybody is like, well, why should I be paying these attorney's fees versus the trust? I haven't heard anything here that tells me that this is anything other than self-created. These parties just don't want to give up. So, Mr. Park, the request was that they need to know that your clients are in agreement with taking this distribution in kind. The 700.
I'll inquire, Judge. I don't have authority for that. That's the first I've heard of it, but I will inquire, absolutely, and I'll get back to them expeditiously.
So the $750,000 price has been agreed upon by amongst the trustees, Mr. Dwiggins' clients, Mr. Gerrard's clients.
Assuming it's a as-is sale, with no covenants.
And that there is no obligation, certainly because she's been over there having it maintained, then she should know that it's in good shape. And so she should have no problem giving you an as-is, whereas waiver of
Already agreed to that, Your Honor.
already obligations. So as soon as Mr. Parks has the authorization from his clients, this distribution can go forward, and Ms. Dwiggins should draft it on behalf of her clients, because this is trust property. Her client is one of the trustees. We do need to have one of the trustees be responsible for doing this. Does it benefit her clients because they're getting this? It benefits all of them because they're all getting a distribution, and this will hopefully resolve this matter for all of them, which this family just needs to do. And
it's already drafted, Your Honor, and I circulated it to Mr. Gerrard.
It just doesn't have the language
Yeah,
we
we need
talked
to
about.
include as
Right.
is and warranties.
And Mr. Park will review that and get the agreement of his clients. They will be looking forward to receiving their distribution of $187,500 to be split between his clients. Mr. Gerrard, does your client have any issues with how this will be paid?
Not this one, Your Honor.
It's
This
good.
is just regular trust distribution.
Regular trust distribution, so we can get this one done expeditiously. I'm going to respectfully again deny, I think that this is the obligation of the trust, because this is a distribution of trust property that the trustees are doing. Mr. Dwiggins will take the responsibility. Mr. Gerrard, you can do one order for all of these issues.
Okay.
Ms. Dwiggins will do the order, we'll do the actual agreement on selling the property, the distribution of property. And Mr. Park, we appreciate your getting those two issues resolved, that your clients agree to this 187 for their share, and that they are signing off on this settlement agreement to the extent that they have knowledge and participation throughout this litigation. Mr. Gerrard's going to do an order with all that in it, and Ms. Dwiggins is going to do the final distribution. That is a trust obligation because it's a trust distribution, not assessing attorney's fees against anybody. Thank you all very much for your
Thank
time.
you, Your Honor.
Thank you, Your
I
Honor.
wish you all nothing but
Thank
the
you, Your Honor.
best. Congratulations on your resolution in this matter. Thank you for your time and attention.
Thanks.
Moving on, we will go finally to